May 10, 2012. Just done dirt cheap. I'm going to share some thoughts regarding filing court documents. Now, the rules of court, when one first starts reading them, seem fairly indecipherable. But after one becomes familiar with them, it's actually pretty straightforward. Court documents that need to go to Court of Queen's Bench and Court of Appeal of New Brunswick. The documents must be on 8.5 by 11 paper. The margins need to be 1.6 centimeters or 4 centimeters or 1.6 inches. Pardon me for that little slip. So again, it's 1.6 inches or 4 millimeters all the way around. That's top, bottom, right and left. The portions of forms that one copies are left single line spaced. Whenever one is writing or filling in a portion of a document, it's best to use 1.5 line spacing. They're quite strict on that when it comes to briefs and submissions, which need to be 1.5 line spaced, and each paragraph needs to be numbered so it's easy to reference paragraphs throughout the brief or submission. So the paragraphs are numbered consecutively, 1 through to whatever at the end of the document. The documents need to be signed and dated, and the pages should be numbered consecutively. If one does that, then they will not likely have any issues with filing court documents as a general guideline. Now, whenever one is filling out forms from the forms of court, what I do is I go copy the whole document. I paste into a Word document. I use Word as I find Microsoft Word is a really great program to use. It's simple, straightforward, easy to format stuff. And another general feature of court documents, just before I move on, is the lettering size must be 12 point size. So if you're using a program like Word, you can select the size of the lettering and just select size 12. And an easy way to adjust the margin is usually you can see a ruler on the far left whenever the program is open. If you double left click in the on that ruler area, a window will pop up and you'll be able to actually decide the top, bottom, right, left margins. As long as you start off with your basics, just getting your margins right, your line spacing correct, 1.5 line spacing, unless you're quoting authorities. If one is quoting authorities, what the rules state is one uses single line spacing and offsets the quote slightly to the right. So if you're looking at the left-hand side of your page, one would see the numbered paragraph going down the page. And then if there's a quoted source, the quoted source will be offset to the right slightly. So there'd be like half an inch extra space, and it would be single spaced instead of double 1.5 line spacing. So it's easy to distinguish what is a quoted source and what is your original material. That's how I do it anyway. Now, most documents need a cover page and an index, and that is straightforward. With a cover page, what I do is I put the title of the document in the center of the page with a long line above it, a long line below it. Say if it's a brief for a motion for an extension of time, I would write, say I'm the plaintiff, I would write plaintiff's brief to be used for motion for extension of time for service. And then I'd put the schedule to be heard, date, whatever the date is. Now above that, so that'd be about center of the page, and above the top break line, put the usual style of court, which would have the court file number, top right hand corner. Then there would be which court it's in, the Court of Queen's Bench Trial Division, and then the district, so the Judicial District of Fredericton, as is most of my documents are at Fredericton. Below that, one sees the word between, and then slightly to the right of that, one has the parties. And the parties are, in the case of a normal action, it would be a plaintiff and defendant, or single defendant. And one writes their name in all capital letters, with underneath the all capital spelling of their name, there'd be the title or the indication of which party that is. So usually at the top it's plaintiff, and then there'll be a separation by a line space. There'll be the word A and D, the dash on either side of the word A and D, and below that, after another space, would be the defendant's name, if there's a single defendant or many. I want to put the defendant's name in all capital letters, and below the indication of their party status, whether they're the word the defendant would be just a single word defendant if it's a single person, or if it's multiple parties, it would be defendants with a plural, like S, and then each party would be named in all capital letters with a comma indicating a separation between one party and the next. Now, for the originating documents, it's been my experience that the originating documents, like the notice of action, statement of claim, either Form 16A or Form 16B or 16C, would have all the names of the parties in full. After that, if one is filing a motion, we can abbreviate the names to be indicated as just the first name. Say if the City of Fredericton was the first party, then one just writes the City of Fredericton, comma, and others. So that's an abbreviation that works to shorten up the rest of the documents that follow. That's in the rules of court. And let's see, and below the center portion, title of the document, there'll be a long separating line. Below that, there'll be the contact information for the relevant parties for whatever that document is. The motion, there'd be the name of the moving party. Say if I was the plaintiff, there'd be plaintiff, then my name, and my contact information, which would be your address, phone number, email, all that stuff. And then there'd be the responding parties, which would be, say, defendant, and below that would be the defendant's contact information. Again, you'd have their name, telephone number, address for service, mailing address, email, fax, whatever information that could be useful for someone to get a hold of them, whether it's the court or yourself. Then that is basically the cover page. The next page in, and oh yeah, the cover page does not have any numbers on it or any indication of a sequence, just the cover page. Now the next page in would be the index. The index is always marked with a lowercase I for number 1, lowercase II for number 2, and it follows in that lowercase Roman numeral sequence for the however many index pages there are. And the index pretty much has to lay down whatever is in the document. There's chapters, or say in a brief there'd be multiple chapters on each topic, so there might be a topic for an extension of time, so the heading of that chapter would be extension of time for service, and then everything related to the argument, the case law, the authorities relied on would be in that portion. Now normally a brief, in my experience anyway, a brief will start off with a statement of facts, and the statement of facts basically has all the facts that one is relying on that they swore in by affidavit. So it's basically a restatement of the pertinent facts that are provided by affidavit with a description that basically puts the facts in a certain light that favors the authoring party's cause. What's interesting is you could have two parties, as in a plaintiff and a defendant, explaining the same set of facts, and it would have a very different light because they would explain it differently. When it's supposed to remain objective, but at the same time, one can explain things in a certain fashion that favors their cause. Now the next portion after the statement of facts would be questions for the court to answer. That generally would be, should the court grant whatever relief the person is seeking. If one is seeking an extension of time for service, there would be the question, should the court, apprised of the facts as presented, considering all the argument, grant the requested time for service? The question, if the court answers in the positive, is in yes, then one will get the relief they're seeking, which is extension of time for filing and serving. This is a hypothetical. And the court answers in a no, as in one's argument was not sufficient to cause the court to believe that the court should grant the relief, and they answered it a no, then the moving party is not going to be successful on their motion. So consider that. Now I spend a lot of time when preparing for a motion. Spend a lot of time and energy preparing the brief to make sure that I cover all the bases, have well researched the topic, and after researching it and finding the common law on the subject, one should have a good idea whether the judge is going to find in their favor or not. As an example, say one is before a Court of Queen's Bench judge, then one would want to find a higher court decision on whatever the topic is trying to sway the judge. The reason for that is if one produces a decision from the same level of court, it's known as a persuasive decision, and the judge could respectively go a different way on that decision. Good. On the other hand, if one provides a decision from a higher court, such as Court of Appeal of New Brunswick or Supreme Court of Canada, then that's called a binding decision. The judge doesn't have the discretion to just go a different way. As long as the case is sufficiently similar, the judge is bound to find in the same way, because that's how the common law works. Common law changes slowly over time, and it's meant to give a consistency to judicial decisions. And how it works is that one should be able to rely on a judge finding a similar way as another judge found. You shouldn't be able to have the same set of facts and two different judges finding two completely different ways. So that's why judges consider the common law and rule in a similar fashion. So, Justice on Teep, May 10, 2012, sharing some procedural basics regarding Court of Queen's Bench and preparing court documents. Thanks for listening. Have a great day.